Madam, you are live now. You can start your session.
Welcome to all the participants of the course on biodiversity protection and farmer rights. It's a pleasure to be back with you in this live session too, along with Professor Narendran and our teaching assistants. We hope that you're enjoying the course, and a significant part of the course has already been given to you. So I'm sure you're actually having a good view of the area of biodiversity protection and also the international as well as the national context of the protection on biodiversity. Today, we would like to discuss with you the context of biodiversity from the point of view of compliance. So we will take about 20 minutes or so discussing with you why the area of biodiversity compliance is now growing. So let me share a few thoughts in the form of a presentation. Okay, I hope you're able to see these slides. So the area of biodiversity compliance is growing, and the relevance of biodiversity to business from the compliance perspective is something which we need to realize, not only from the international context, but also from the national context. Since we have the Biological Diversity Act 2002, there is a need for compliance with respect to the utilization of bioresources. If you recall, the three basic objectives of the CBD, which India has implemented in the form of the biological diversity legislation, talks about three important principles. One is conservation of bioresources. Second is sustainable utilization. And the third is access and benefit sharing. We must remember that these are interlinked objectives. So for the best use of biodiversity, it is also important that sustainable utilization is one of the important pillars. Now, given that as the context, we see increasing use of biodiversity and the effects on biodiversity more from the end of overappropriation. So when natural resources are appropriated more than their sustainable utilization is when we see the impact on the resource as well as the ecosystem. And this is where the relevance of biodiversity compliance comes into picture. A great amount of business in terms of appropriating resources where raw material to product conversion happens, agriculture biodiversity is appropriated. Every other type of biodiversity in the realm that it is now impacted. So there are tremendous reasons for monitoring biodiversity and assessing the impact of overappropriation. And this is exactly the place where we are looking at conservation of biodiversity, which is somewhere in the conflicting aspect of where businesses are also having to utilize biodiversity. So where do we reach the middle line? On one end, we have the conservation goal. On the other end, we need to continue to allow business entities to utilize bioresources. So there comes the important aspect of regulation of the need of regulation for biological resources. Of course, there are several stakeholders involved in this process. Administrative authorities under the purview of the biological diversity legislations have mandates in order to ensure not only monitoring of bioresources, but also assessing the impact. Internationally, the specific focus on the linkage between biodiversity and business was discussed in the conference of parties meeting in the 10th meeting of the COP10. So it is at this stage they started looking at asking the different stakeholders what are the ways in which the bioresources are being utilized and how can we have sustainable utilization of biodiversity, and do we have mechanisms and tools in order to assess and monitor the use of biodiversity. Given the fact that, as you have studied in the earlier part of the course, we continue to have greater and greater number of species under the risk category, depending on the stage of risk at which they are, whether they are least threatened, threatened, highly threatened, endangered. Now, given that scenario, it is also important to take those into considerations when we look at the context of biodiversity and business. Now, what about the expansion of protected areas? That also becomes one particular paradigm to look at from the point of view of this context of biodiversity and business. Increasing relevance of renewable sources of energy means that forest resources are also being looked at. For instance, poplar in many other countries are being looked at as a source of energy. When that is a dedicated activity, what would happen to bird biodiversity? What would happen to the other components of biodiversity is one important consideration. Would it lead to reduction of genetic diversity? Because ultimately, we know that CBD advocates what is called the ecosystem approach. And so if one part of the ecosystem is disturbed, it would have ramifications so far as the other parts of the ecosystem. So it is in this context that the COP10 initiated the discussion so far as the linkages with business and biodiversity. We also are aware that UNCTAD has been working on the linkages with respect to business and biodiversity from the biotrade perspective. In order to support the objectives of the CBD, the UNCTAD has also taken up a lot of activities. In the course, you would have studied the various biotrade principles, which form an important part of the work of the UNCTAD. From COP10 to where we are looking at the more recent conference of party meetings, where there's increasing need that is being realized with respect to how we can enhance the level of biodiversity. So the Kunming-Montreal Protocol talks about the targets with respect to several targets. And since we're discussing today the context of biodiversity and business, it is also relevant to discuss the target 15, where measures for systematic reduction of the negative impact and risk on biodiversity is one target. And what are the ways in which sustainable production can be enhanced? So this is one target that was looked at from the Kunming-Montreal framework itself. We are also aware that the context of biodiversity has become relevant for even small enterprise today. And how do these small enterprises work with respect to the availability of biodiversity is also very critical to understand. And increased dependency on nature, but lack of resources is the dichotomy that we are facing at this point of time as we see with respect to the world biodiversity map. On one end, we face the risk of the sustainable utilization of bioresources. On the other hand, we also can look at the opportunity that business can take in order to participate in the overall conservation objective of biodiversity. Businesses can actually take up plants which are threatened, resources, biodiversity which is in the threatened state, and research and look at how sustainable outcomes can be realized for the future. This not only includes private entities, but this would obviously include a lot of governmental interaction and also role of international organizations in order to shape up that. So this, therefore, on one hand, we face a threat to biodiversity, but on the other hand, such threatened species, not much research work has happened. So how could we look at a partnership of private entities and the entities either under legislations or even general, which are working with environmental goals, to work together to turn that also into an opportunity? Now, when we look at the Indian context, under the Biological Diversity Act, Section 18 of the Act stipulates the role of the National Biodiversity Authority in regulating access to resources. So, under the three-tier mechanism of the implementation, we have NBA at the central level, the State Biodiversity Board at the state level, and the Biodiversity Management Committee at the local level. Each of them have a role in regulation of the use of bioresources. Now, access to bioresources can happen in which different way? We know that Section 3 of the Biological Diversity Act is relevant from the point of view of access to bioresources from the perspective of biosurvey, bioutilization, commercial use, and for activities that lead to commercialization. Particularly in the context of preventing biopiracy, this section has a lot of relevance. Any foreign participation or any non-citizen, any corporation outside the country, indulging in any of these activities would require a prior approval of the NBA. So this is one monitoring role to regulate access to resource. It does not end there. Now imagine a lot of research comes out of the use of bioresources. What happens to data generated out of the use of bioresources in terms of the experimental information, in terms of the finalization of results, in terms of sequences, in terms of identified molecules or the products out of those research? Any sharing of that with entities outside, with non-resident Indians, with non-citizens, will require again a prior approval. So any transfer of research results related to the use of biological resources will also require a prior approval. Now, another important aspect is we know the regulatory role of the NBA as far as the intellectual property derived from the use of bioresources. So if you're coming up with an invention and you're interested in filing a patent in India or outside India, whether it is an Indian or a non-Indian, the prior approval of an NBA is a must, which means the NOC is an important prerequisite with respect to the patent application filing. So it is not only resource, but through the resource use to the endpoint, the NBA regulates activities with respect to use of bioresources. State biodiversity boards in their jurisdiction of the respective states also regulate the use of bioresources. Any collaborative activity happening between an Indian entity and another institution will mean that that will also go through the scrutiny of the Biological Diversity Act in the form of Section 5. Some pre-existing agreements which are already reached by way of international cooperation will be notified, and those notifications lead to a scenario where those agreements and that research, that collaborative research, is exempted for the compliance under Section 5. So when we look at the entire fabric of the Biological Diversity Act, we are clearly, it is important to know what are the obligations and thereby the compliance that institutions working on research and also business entities working with biodiversity must be aware of. Now, this is where we look at the relevance of the application procedure for access. So, we discussed in the different provisions the access to bioresources for different purposes. There are separate procedures available with respect to application for the approval for use of bioresources. And if NBA finds it suitable that the approval may be given, it should match with the agreement, which is the access and benefit sharing agreement that needs to be signed by the. That means access to bioresources would mean that benefit sharing is what that needs to be taken care of in the process of access. So, in view of the application of the Biological Diversity Act, the access and benefit sharing provision is very important, not just for a one-time benefit sharing, but through the agreement, NBA can continue to monitor the utilization of bioresources. So, at every stage, the conservation objective is kept in mind so far as the bioresources are concerned. One important facet of the legislation is also at every stage, when you look at the header of this section, it says biological resources and associated knowledge, which means it is not just the plain bioresource, but also the associated knowledge associated with biodiversity also is relevant. So any access to the knowledge associated with resources also will require an approval from the National Biodiversity Authority. The National Biodiversity Authority shall consult with the State Biodiversity Body, the State Biodiversity Board in whose jurisdiction the resources. If the State Biodiversity Board thinks that the resource at this point of time cannot be shared because its conservation target is hit, so be it, the approval may not be given. Many state biodiversity boards also display on their websites a ceiling period by when that the resource will not be made available. So these form an important part of the monitoring part of bioresources so that bioresources can be sustainably utilized. Now, at the local level, the Biodiversity Management Committee has a say so far as the approval mechanism of these various ways in which biodiversity can be accessed. If the Biodiversity Management Committee is of the opinion that the resource will be coming under a this would limit the resource, or a community will be seriously affected if biodiversity is accessed, then that means that the approval mechanism may not be going forward, or an approval mechanism may need to be modified, and in the modified way, an approval mechanism can be effected. So therefore, this is the three-tier mechanism by which the resource utilization happens. So in terms of business, it is important for business units to understand that the compliance would come under the purview of these particular sections. Why? Because ultimately, the conservation target should not be hit. And so therefore, these are necessarily from that perspective. What you see on this illustration is the specific form for the application and who are eligible to apply and what are the fee charges. Now, the access and benefit sharing is done by the guideline available in India under what we call the Operational Guidelines for ABS 2014, which spells out the way in which access and benefit sharing should be done. We also have additional forms identified specifically for the purpose of looking at how the access and benefit sharing can be. And there are several instances where business units have been very positive when it comes to biodiversity and actually have gone ahead and done the access and benefit sharing. So it is not only bioresources which can be impacted by the use of biodiversity, but even communities staying in the vicinity of bioresources may be also impacted. So therefore, ABS mechanism considers not just the conservation of resource, but also livelihood sustenance. And of course, there is also another facet of the Biological Diversity Act in terms of the research activities. Section 7 of the Biological Diversity Act talks about prior intimation to the State Biodiversity Board when you take up activities in relation to research. Again, this brings in the monitoring role so far as use of biological resources. So even indirectly, research activity should not lead to what we call depletion of a resource or a loss of traditional knowledge associated with that resource. And it is with this perspective that the requirement of prior intimation is very important to be looked at. Now we have Rule 16 of the Biological Diversity Rules, which have several factors that need to be considered when approval mechanism is given. So that again brings in the facet of monitoring. There is also a requirement of compliance from the end of the applicant. When an applicant is submitting the Form 1 or Form 3, it is also important at that stage to indicate not only the nature of the resource, but in what terms the resource will be utilized over a period of time, and how much of that resource will be utilized, and for what purpose it will be utilized. So therefore, any non-compliance and that will attract the Biological Diversity Act, and therefore there are serious concerns that may arise, and Section 56 of the Biological Diversity Act may be invoked, and therefore there could be very serious consequences with respect to the misappropriation, utilization of biological resources at the cost of the conservation objective. So this is something one has to look at. So moving forward, we also know that there are different types of bioresources that are utilized. We have plant bioresource, we have microbial resources. So the Form C provides us a mandate of also indicating the need for deposition and what kind of deposition has been done and accession numbers to that. So at every stage, this is becoming relevant from the perspective of, again, where the bioresources are being utilized. So greater scrutiny is what we look at it, from the resource utilization part. Now, we also have a parallel when we are looking at the joint application of the Biological Diversity Act 2002 vis-a-vis the Patents Act 1970. Anyone who is applying for patents and utilizing bioresources from India not only need to be compliant with Section 6 of the Biological Diversity Act, but also there's a separate aspect of Section 10, subsection 4 of the Patent Act, which also mandates the need for disclosure of the origin of the source of the biological material. So therefore, taken together, it only strengthens the mechanism of the need to know from where the resource has been taken. And we, in the earlier live session, Professor Narendran has already discussed with you disclosure and how the concept of disclosure, as we see going forward post the treaty, is going to become very relevant to that understanding. So we know that industry accesses a lot of bioresources for making several products. We are talking about enzymes, drugs, color, dyes, products out of biodiversity, and a whole lot of things in terms of even looking at advanced technologies. For instance, plants are being used for genetic engineering. So a lot of research is happening and products are coming out. And so therefore, understanding the relevance of these from the context of resource access becomes relevant. We have an expert committee on ABS in the NBA, which deals with scrutinizing these particular applications for the approval mechanism. So therefore, when we look at the resource access, it is important for companies to be compliant with respect to each of the compliance mechanism that is provided, either it is Section 3, Section 6, Section 4. And if that is not done, then obviously that calls for need for looking at the offenses that come under the legislation. So liability will be attached to companies and also to individuals so far as non-compliance is concerned. And this is enumerated in the biological diversity. Now, what happens from the point of view of compliance? So today we need biodiversity compliance as an integral part of every unit, every business unit. So no longer are the days when business units would access resources from the forest and simply churn them into manufacturing and make products. You need to now keep a register of what are the different parts of the plant, when are you accessing the collection, have you taken care of the approval of the biological diversity under the Biological Diversity Act with the respective under the respective boards. So this compliance has become an important thing. And remember that this is matching with the relevant ABS that needs to be done. So there are cases, what you see on this illustration, a case of the biopharmacy case where nevertheless you need to take ABS is what the court ruled when it comes to a case where Indian company did not have foreign participation. So they said, we don't need to come under the compliance of Section 3. The court said, nevertheless, you have to do because obviously, if someone is going to access the resource for a product, they would obviously be depending on Indian companies to access resource. Now, there's another case of DC Shriram Limited versus NBA, where again, the context of Section 7, that is the prior intimation, has been looked at. So today we know because of the operability of the Biological Diversity Act, it is important for industry to turn towards the compliance mechanisms so far as Biological Diversity Act is concerned. So the next time you enter into an airport, which is a huge airport that is coming up in the area, would they require biodiversity compliance? Yes, absolutely, they would require biodiversity compliance because imagine if an airport has to be made, a whole area is going to be denuded, the entire place in terms of the plants, or if it is in the fringes of a forest, or even livelihoods. So it is no longer about simple environmental impact assessment thing, but it's also going to come under the compliance of the biodiversity legislation. So this is where we need to realize the value of this legislation. Another important aspect is that if there is a pond nearby the company and there's let's say a wetland, and systematically what comes as an efflux from the industrial unit goes into the pond, and if it disturbs pond the aquatic biodiversity, yes, that would be calling for a serious look from the point of view of the Biological Diversity Act, where offenses by companies can easily be involved. So it has now become very, very relevant for companies to look at the overall biodiversity compliance in terms of making sure that the local biodiversity and the local livelihoods are not affected. And so many companies have already stepped up their biodiversity compliance by bringing in what we call green measures, mitigating the environmental risk, ensuring that there is internal compliance in terms of several biodiversity codes that people are using these days. So that is only supportive so far as the entire. So sustainable practices for businesses becomes very relevant. And I will not name any specific companies in this, but taken together, if you see, the overall environmental awareness has grown, obviously, and the need for biodiversity education internally for employees of the companies will bring them much in closer to the understanding of how biodiversity compliance has to be met. And this is not just for the commercial division or let's say the regulatory division. It is absolutely imperative in the manufacturing departments to know. And for instance, and for that matter, the entire employees of the companies must be looking at the biodiversity compliance. In fact, many of them also have what is called biodiversity audits. If it is a company which is solely based on utilization of bioresources. So therefore, I gave you examples of airports and things like that. So today, companies are much keen on building the what you call zero waste scenarios and also maximizing energy use, but minimizing on the loss to the environment. So that is where I would close and maybe also invite. I also invite Professor Narendran's views because he has been involved in the compliance and the governance. Sir, if you would like to add some points here.
Thank you, madam. I was listening to the presentation. So, madam, in this course, actually, now they are entering into almost, I think, fifth or the sixth week, and they are now directly moving into the biodiversity compliance aspect, which you have explained very well in your presentation. So, I think in the fifth week, they are studying about biodiversity and intellectual property rights. So, they will be looking at the interface between the biodiversity governance system and the intellectual property system under the TRIPS and WTO system. So after that, they are going to plant breeding and related aspect, farmers' rights protection and related aspects. And then in the seventh week, they are moving directly into biodiversity and compliance procedure and practice, where they will be again looking at the Biological Diversity Act and how the compliance under the Biological Diversity Act can be ensured. That the application process that you rightly explained will also be covered in the seventh week. So that means now the course is towards the almost towards the going towards the last part, and in the eighth week they will be looking at biodiversity and human well-being. With that, the course will be ending. So actually, we have introduced this course at a very right time because now this global biodiversity framework has come, and also the new amendments to the Biological Diversity Act is also taking effect. So that makes the course highly relevant at this point of time. Students, I think, have raised some questions, which we can take up now, or
If you're willing to take up any questions, if there are.
So, I think, can I start with one question that I have come across?
Yes, please.
Yes. So they have one question that has come is whether these amendments to the Biological Diversity Act has come in force. So yes, it has come into force. The 2023 amendment has now come into force. So this has made some significant changes, which Madam has already talked about in the presentation. So now the changes are in effect, but the rules are yet to be framed. So I think only when the rules are framed, then only we will get to know like whether the forms will be changing or not. But right now, the act is in force, but the rules are yet to be brought into force. That is the first thing. And second, there was one question related to the biodiversity compliance in EU. So EU also has the guideline. They have the user country measures. So now in EU or member countries of EU also, it is now a major requirement that biodiversity compliance has to be ensured when anybody is utilizing the resource. So I think there are only very few questions that has come, and most of the issues, Madam, you already covered in your presentation. So I think there is no need to separately take up those things.
I think so that is what it is. And in fact, in the interest of each of the participants, we would also like to know your view on how you would like to inclusively look at biodiversity. So maybe we will send you a spreadsheet across where you can share your thoughts about what do you think about biodiversity compliance. And biodiversity compliance, I believe, is never only at the business level. It comes at the individual level. So therefore, it is integrated, because environment is not only a business's goal, it is also an individual goal. So therefore, we'll be happy to also hear your responses or your experiences when you have looked at impacting biodiversity getting impacted. It could be a very simple thing that you were walking beside the lake and, maybe 5 years later, you saw the lake in a different form. Whether it was positive or negative, then does it mean that we need compliance? Yes. So you can put in some of those thoughts, which could be even informal. for us to see how well you are actually looking at the inclusive aspect of biodiversity. Thank you. Please continue to be engaged with the course. We are always available. You can use the entire discussion group, and our TAs are available for you to address some of the preliminaries, and you can also write to us otherwise. We wish you all the best on behalf of Professor Narendran and myself. Do well, and also all the best for the exam, because this is the second live session, and otherwise we are not doing any other additional ones. Yeah, that's about it. Thank you. Thank you all so much. Yeah, if we don't have any further questions, maybe we could close the session, if that is okay.
Yes, you can.
Yes, madam. I think we can close the session.
Thank you. Thank you all, and all the best. Yes, sir. Please.
If they have any further questions, they can put in the discussion box. We will reply to that.
Absolutely. Yeah. Thank you all. Thank you so.
Thank you, madam. Thank you, sir.